The defense argues the defendant has learned his lesson after spending nearly 2 weeks in jail, losing his job, and missing Thanksgiving. They claim he understands the real impact of his actions now.
Yes, Your Honor, please for Brandon Bird on behalf of Carlos Mack.
Good morning, this is Hope Lord County on behalf of Mr. Mack on the license case. I don't have the case number in front of me.
The driving while license suspended case.
Right.
That would be the case ending in 1404.
Thank you.
Your name, sir?
Carlos Mack.
All right. What are we doing?
I respect, Your Honor. We need to talk to the prosecutor. If we can get a little bit more time to find out an offer, but I would like to address bond.
I'll adjourn the matter to December 17th, 2025 at 9. Is that, Ms. Perrone, you wish to do that also?
Join that request. Yes.
All right. So I'll adjourn both cases to the December 17th day. All right. Esteban.
My client failed the test, and that was the reason he got put. Failed. He was drinking while he wasn't supposed to be drinking. Let me just put it like that.
Yes.
And he'd do a little bit of time within the Washington County Jail, and I believe he learned his lesson, Your Honor. He missed Thanksgiving. He has a mother who he helps take care of. It was actually paralyzed on the left side due to the fact that she had a stroke, helps take care of her mother. And he understands that doing those things not only risk his freedom, also suffering from a physical condition, a hernia, in which he needs to get taken care of. But the biggest thing is, I understand that might be possibly be done in the Wayne County Jail. The biggest thing is that my client learned his lesson, Your Honor. He learned his lesson. First of all, the Washington County Jail is one place he doesn't want to be, and hopefully is one place that nobody wants to be. But him not being able to stand up and take care of his responsibilities and be with his family affected him enough where I believe that he wouldn't commit the same mistake again. Or we can't even call it a mistake. He won't violate bond again.
The judge questions how the defendant can be trusted again, especially after violating bond while already on a SoberLink monitor. The court raises serious safety concerns.
That's what he violated on.
We could put it on again. We're coming at the mercy.
So
we're coming at.
Why would I just continue to do the same thing?
Because he just sat in the Washington County Jail, and you're understanding judge like yourself, Your Honor. Respectfully, I understand you understand the conditions of being in the Washington County Jail.
Oh, it's a beautiful jail, comparatively.
Yeah, when you're on the outside, you know. But
I don't know. How you know? Not on the inside.
I just go back there to talk to my clients
He
sometimes.
picked up a case.
I go back down there. No. But Your Honor, respectfully, we're begging the mercy of this court.
I understand what you're doing. I also understand. Here from the review in a moment. He's what, a 177, and then when he violates. He's almost a point. He's a 0.08, almost a 0.09 when you violate. And then, more importantly, in that, doesn't retest. So,
one thing about it is, after not doing that, he walked himself in here, knowing the fact that there was a potential that he was gonna get arrested. He walked himself in here to deal with the consequences of his actions. And after dealing with the consequences of his actions, I believe that he has a thorough understanding of what could really happen. He lost his job. He lost his job due to this. He lost the fact that he can't take care of his mother due to this. He lost his Thanksgiving due to this. And he lost his freedom for almost 2 weeks, Your Honor. It's about a week and a half. 2 weeks. He lost his freedom. He lost his freedom for 2 weeks. that gives anybody a chance to think about their decisions and the decisions that they make. He made some very bad decisions. We're not trying to get around that fact. And he
counsel, I understand that, but what I'm getting at is he comes in here with a case where he's a 177, I think it's BAC, and then he gets a PR, he's released. The major condition, because it's a drinking and driving case, is that he not drink, and then he does.
It's no excuse. It's no excuse that I could give you for that, Jan. There's no excuse that my client's trying to give you for that. There's no excuse that my client's trying to give you for that. And he's not trying to make excuses. The fact of the matter about it, moving forward with this, I understand the predicament that you're in and what you're trying to ask of me and what you're trying to ask of him. How can I ensure that he won't drink when I already gave him the opportunity and he had a sober link on? So that was the least restrictive means of.
Let me put it.
The defense highlights the defendant's responsibilities at home, caring for his paralyzed mother, and insists he's motivated to change because too much is at risk.
Gets behind the wheel and hurts or kills somebody. What do you want me to say to that person?
I don't think there's anything that we'll be able to say besides remand.
I'm not going to be in that position for the people.
He has a 2010 prior OWI as well, Your Honor. It might be an OWVI, but I remember looking at his record. It was a .177, not charged as a high VAC due to my office recognizing the percentage differentials that happen when blood is tested by the Michigan State Police Lab. However, if the court were to entertain release at any time, people would request a scram tether.
And that's 15 years ago, Your Honor. That's 15 years ago.
The behavior hasn't ceased.
We can't,
I'm not holding that against him necessarily, but the behavior has been repeated.
Right.
So what, I got to wait for the third time? Then you want me to do something?
No, I'm not saying that. I'm saying that no driving, no driving condition in his bond. Put back on the scram tether. This is the longest that he's ever spent in jail. This is the longest that he ever spent in jail. And he didn't have the same problems back then that he had now. We're dealing with having somebody that's dependent on him. I greatly understand your concern. I do. And like I said, I can't guarantee anything.
I know.
I can't guarantee anything, but I know one thing. After speaking with my client, I spent some time speaking with him in the Washington County Jail. And
the judge emphasizes the danger if the defendant drinks again, drives, and hurts someone. The court refuses to be responsible. Public safety is the priority.
And be a better person. And that's one reason why we're
He had that opportunity.
He did have that opportunity and he messed it up.
Big time.
He messed it up big time. And he did 2 weeks for it. He lost his job for it. He suffered multiple consequences because of his actions in that matter. And he understands that he can't suffer those consequences anymore. It's too much on the line. It's too much dependent on him. And it's too much dependent on him. And if he does take that risk, then he's at risk of losing more than these 2 weeks.
Here's what I'm going to do. I'm not at this point going to change the bond. This bond will continue. And I adjourn this out to the 17th. Sometime between now and then, I may look at this again.
Despite emotional pleas, the judge keeps the same bond, saying the defendant put himself in this situation, and the court has already given too many chances.
I've given the opportunity, and I don't know how many opportunities, and I am not going to be trying to explain to some parent why the child is dead because he got behind the wheel. Not going to do it.
Well, I appreciate you for hearing me out. I do, Your Honor. And there's one thing that I do want to mention. It's not to change your opinion right now today. But my client, it just something to keep on your mind. My client did say he's been on the pad that they're giving him, working. What was the class?
Recovery.
Working with the recovery while he's been in Washington. So he has taken some steps forward. But thank you. See you the 17th, and I appreciate you for hearing us out.
Not a problem. Thank you.
Thank you.